signal next to the IT person's name, and after that you can start speaking.
All right, sounds good.
All right, wonderful. Thank you, and all the best to everyone. It promises to be quite an interesting and engaging discussion.
Thank you.
All right, I see that there's a green signal from the IT department, and I would like to proceed. At the onset, greetings to everybody present. Thank you for being here. My name is Nivedita Pundale, and I'm a student member of the Jindal Society of International Law. I was inspired to host today's lecture owing to my participation in the Lead and Sari in Law Moot Court in 2021, owing to my discussions with Dr. Sreejith, who had very generously and kindly agreed to coach us. I was acquainted with complex topics of international aviation law. Now, drawing inspiration from our discussions and deliberations, I thought it would be best to present such ideas in the Jindal Society of International Law's lecture series. It is thus my immense pleasure to host the lecture today. Before I introduce the topic and our speakers for the lecture, I would like to share a few words about the society. The Jindal Society of International Law is a student-led initiative under the aegis of Center for the Study of United Nations and guidance of faculty coordinator Professor Dr. Veselin Popowski. Founded in 2020, the society is an initiative to provide a platform to young international law enthusiasts. The inaugural address and official launch of the society was on November 18, 2020. The society was officially launched and inaugurated by Herbert and Rose Rubin Professor of International Law, Jose Enrique Alvarez of New York University, along with the Vice Chancellor Professor Dr. C. Raj Kumar, Professor Coordinator Professor Dr. Veselin Popowski, and Dean of Office of International Affairs and Global Initiatives, Professor Dr. Mohan Kumar. The purpose of this society is to increase student interaction with the subject matter of international law through its various initiatives. Rather than being primarily research-driven, we intend to offer a host of experiences that contribute towards skill building, thereby increasing the knowledge database available to students. This society is an attempt to bridge the lacuna by streamlining resources and inculcating an overall interest in the vast expanses of international law. We aim to provide a space to young international law enthusiasts like myself to nurture their interest in the field. The spring lecture series of 2022, titled Colloquium on Challenges to Global Governance and Humanities in the 21st Century, offer a compendium of scholarship from the academy and professional experience from the bar. Over the past year, the Jindal Society of International Law has hosted over 100 speakers from renowned foreign universities, members of International Law Commission, international law firms, United Nations, Institute of International Law, World Bank, and Hague Academy of International Law. Through our previous series, we endeavored to study the different contours of international law through the speakers who covered and addressed their respective areas of expertise based upon their years of research and practice. Given the vast ecosystem and the engagement of international law in it, the society aimed to study the fragmentation and fertilization of various disciplines in the ecosystem of public and private international law. Over the years, the society has become a forum of thought-provoking discussions due to the engagement with experts aimed at exploring the ecosystem of international law. Thus, as a result of the spring lecture series, it is important to understand the law and its challenges from a broader, different, and differing vantage points. Acknowledging international law as a creation of states, it is also important to understand and appreciate the social sciences and humanities that played a key role in shaping the law. Thus, a broader study becomes critical. Through the series, it is also hoped that one will develop a deeper understanding of Philip Jessup's magnum opus, A Modern Law of Nations, an introduction in 1949, and I quote, "So long as the international community is composed of states, it is only through an exercise of their will, as expressed through treaty or agreement, or as laid down by an international authority, deriving its power from states, that a rule of law becomes binding." Thus, to speak on classicism and modernism, the philosophy of international aviation law, we have amongst ourselves today as speakers who are titans of international aviation law. While one belongs to the bar, the other belongs to the academy. Mr. Nitin Sareen is an advocate in India, a solicitor in England and Wales. Mr. Sareen is a world-class legal specialist who is known for his keen and deep passion for aviation. Mr. Sareen has studied law in India and has completed his advanced LLM in Air and Space Law from Leiden University, Netherlands. After completing his master's degree, he returned to head the aviation department of the firm. Mr. Serene is an expert in aircraft financing, aircraft leasing, dealing with regulatory issues, and other cross-border asset-based financing. He also specializes in drone loans. Apart from his expertise in law, he is an aviation enthusiast and aircraft spotter. Mr. Serene has, over the last decade, represented some of the world's largest lenders, equity participants, international airlines, airports, and lessors for their transactions in India. He has also advised several international airlines in a variety of matters, ranging from market access to employment issues. He's the founder of the Sreejith M.B.L annual student essay contest on aircraft finance and leasing, a guest lecturer at the International Institute of Air Law and Space Law and Leiden University, as well as a qualified IATA trainer is also instrumental in organizing the Leiden Sareen International Air Law Moot Court competition. We also have amongst us today Professor Dr. Sreejith, who is a professor and executive dean of Jindal Global Law School, OP Jindal Global University. He holds the LL.D with high honors from University of Lapland, M.Phil from Jawaharlal Nehru University, M.B.L and LL.B both from the University of Kerala. Prior to joining Jindal Global Law School, he worked with reputed institutions like the Arctic Center, the University of Lapland, National University of Advanced Legal Studies, and the University of Kerala. He is the author of Transcending Jurisprudence, a critique of Architectonics of International Law. He has also published in journals like Third World Quarterly, San Diego International Law Journal, California Western International Law Journal, Journal of Space Law, Journal of Air Law and Commerce, San Joaquin Agricultural Law Review, Air and Space Law, Space Policy, and a multitude of other journals. He sits on the editorial board of the Indian Journal of International Law. He has also served as special issue editor of Journal of Human Values and Jindal Global Law Review. With those words, I now invite Mr. Sareen to share his perspective on the topic.
Good evening, Nivedita. Thank you very much. I would like to start by saying that when an introduction takes so long, that means a person is very, very old. So it doesn't reflect on any achievement. It just means that a person has been around for a long time. Thank you very much. And I would like to start by saying that it was a pleasure to have you for our moot court a few years ago. You did extremely well. Professor Sreejith, it's a pleasure to be on the same panel as you. Ankit, thank you for inviting me. And Mr. Vikas, thank you very much for your IT support today, without which it would be very difficult to manage the affairs. I would like to start with a brief introduction about myself. I'd like to call myself an aviation lawyer, but in all reality, I'm just a plain advocate who has a big passion for aviation. I was lucky enough at my law school and after I qualified to specialize in the field of my choice, which was aviation. It's just to give you a little bit of background, I did, litigate for over 10 years. So a small note for everyone listening, litigation is a very, very important part of law, irrespective of where you branch out. I was a very mediocre student my whole life. I was not very interested in academics, mainly because there were just so many other attractions when you're younger. And I really believe that, higher studies should be carried out at a slightly older age where you know what your interests are. And I'm really glad that I waited to perhaps do a PhD one day till this stage, where I really truly and know what the research I would like to do. Going forward, after I completed 10 years of litigation, I was lucky enough to be able to engage with classmates at the Leiden University and get work in India. And again, it's just pure luck that we are slated to be the third largest aviation industry by 2030. Those were the predictions pre-COVID, but I see no reason why that should change just by virtue of our population. When I got this invitation, I will admit I had to Google both terms, classicism and modernism. They are not terms that come across on a daily basis. So just for the benefit of all the viewers, I have the definition of classicism here, which is quite literally the following of traditional and long-standing or established theories or styles. Modernism, of course, is, as the term says, that it's the modern view, the dynamic view. It's really the 20th, it technically came in the late 19th century and the early 20th century. But for most of aviation, we're really talking about the 20th century because it's so young. Giving a brief introduction to the topic, we all know that laws are always changing and always chasing development. Only a fool says that laws are up to date and laws are beyond current development. That is never the case. It's always technological and other development is always faster, and laws are always trying to catch up. That's how it has been. That's how it will be. That's how, why would laws change if technology hasn't changed? So especially in the field of aviation, whether it's classicism, whether it's modernism, the one paramount theory is safety. Irrespective of whether we're talking about the early 1900s, whether we're talking about the 1950s, whether we're talking about the 2000s, safety is paramount. When you're flying almost at the speed of sound, 11 kilometers above the Earth's surface, you want to know that you'll be able to land safely, and any small mistake can cause an issue. To give you and all the viewers an idea about classicism as far as international aviation law goes, it's very imperative for people to understand the timeline that aviation went through. It's all well and good when we think about aviation, but it's very difficult to fathom how much progress has been made in such a short period of time. We often complain these days about Wi-Fi not working on an international flight, and we will essentially take it up with the crew and say, hey, Wi-Fi is not working. What we don't understand is less than 120 years ago, no human had really ever flown on a powered flight. So the power of the human mind, the power of technology, the power of our ability to change the world that we live in is absolutely immense. With this, I start with the background, going back to 1903. Again, I'm not going to waste too much time. All of us have learned about the Wright brothers and them flying the Wright Flyer. Just to put things into perspective, the first flight lasted all of 12 seconds. So that's from the moment I've started, talking about the history till now. In a very short period of time, now imagine this, 1903, let's not talk about years. Let's just say 2 years from the first powered flight ever. From 12 seconds, they managed to improve that to 39 minutes. I mean, just think of that from a perspective of development. That's absolutely incredible. In 1909, we get the first rudder and stick, as they say, for persons who are familiar with how aircraft fly, that, one stick controls the rudder as well as the other flight controls. In 1909, again, now we're just talking about 4 years after the 39-minute flight, we have a gentleman crossing the English Channel. Fantastic. I mean, it's completely unheard of. Now, what does that bring with it? Now, put yourself in that scenario where you're in the early 1900s. You have this massive development or technology change that's happening. What happens? Imagine if you didn't have any rules. If I was sitting here in Chandigarh where I am, I would fly to Delhi. I would fly to Ambala. I would cross the border. I mean, what is a border when you have the ability to cross it? It was at this point where the French authorities got fairly upset with the German authorities, where it was a free-for-all. People were flying in balloons, people were flying in powered flight vehicles or aircraft, and landing in different countries without prior permission, without any idea of the repercussions. The French were slightly upset because the German authorities were actually sending military personnel, not for any particular purpose, but they were presumably the daredevils and presumably the ones who had the budget to do that. This led to the first diplomatic conference in 1910, where for the first time in the history of humankind, people got together to discuss the issue regarding dealing with air navigation, dealing with things to do with aviation. Things never flew before that. So unfortunately, that the convention in 1910, according to current estimates, was a failure. But however, a major part of the clauses were agreed. What really came out of that 1910 conference was the fact that nations sort of agreed that, okay, apart from territorial borders, so you have your border around your country, we will also agree that the airspace around the country will also be ours. So it sort of gave a color to sovereignty of airspace over a particular nation. However, there were various numbers of disagreements that were there. Now, again, going back to put yourself into 1910. There's this huge amount of development taking place. A year later, in 1911, for the first time, an aircraft is used as a I wouldn't say as a weapon, but as a vessel to carry weapons. Where in the Italian-Turkish War, the Italians actually flew 4 grenades and dropped 4 grenades from a flying aircraft on Turkish positions. Now, again, the development continues. It keeps going on. We reach 1914. World War I, unfortunately, breaks up. And this is where there's a huge surge in technological advancement, presumably because there's a lot of funding that's coming in from a government, etc. Where not in military aircraft per se, but in reconnaissance aircraft, where it's really gathering information, gathering frontline positions, etc. was key. At this stage in 1914, now I'm going back. This is only 11 years from the first 12-second flight. We have a German aircraft that flies up to 24,000 feet. Those are modern day altitudes. So it's absolutely astounding the kind of progress that we've made. Again, this is all, the progress is all thanks to the military aspect of things. In 1918, we have the end of the war. In 1919, of course, after the end of the war, everyone, again, I say, the human race is like the law. We're very slow on the uptake, and everyone's now realized that, okay, aviation is something that we need to tackle, something that we need to contain, something that we need to talk about. This leads to aviation being a very important topic, studied, talked about, and discussed at the Paris Peace Convention in 1919, which ultimately led to the Paris Convention. So we had the Paris Conference in 1910. We had the 1919 Paris Convention, which was actually, for the first time, there was some text which was agreed upon, or some text which was slightly understood between parties. This was, of course, did not come into force till 1922, where they got the 14 ratifications that were required. So again, progress is going on. Aviation is developing. We reached 1939 with the advent of World War II, which again, we see huge surges around the world wars. So aviation, without a doubt, does see its genesis and its basis in war and technological advancement when we have to do it. The only difference in 1939 as opposed to World War I was that there were already very well established networks around the world for aviation transport. So earlier it was a novelty. Now people are slightly getting onto the bandwagon, saying, okay, hey, if I want to pay a huge amount of money, I can still have mail sent, or if I want to travel, I can travel. Now, what does this lead to? This leads to the world coming together again in 1944, saying, look, we have this whole network of travel or trade that's happening via aviation. We need to solidify that. We need to put it in a proper codified form so that we all understand what's happening. This led to the United States inviting 55 countries in 1944. Now, let me go back one step, which a very important fact that I forgot to mention. In 1910, the Europeans essentially did not invite the Americans, because at that time, technology really, kept the Americans in a cocoon with two oceans on both sides. So we are back to 1944, where the United States has invited 55 states. Finally, in December of 1944, we have 52 nations who signed the convention, which was discussed and deliberated at Chicago, now prominently known as the Chicago Convention. The Chicago Convention came into force 3 years later, again, as usual international law goes, with obtaining the minimum amount of signatures that are required. What the Chicago Convention does is it deals with civil aviation. It deals with all aspects of civil aviation. Unfortunately, in the time that we have today, I will only be able to skirt upon the larger scheme of things, because this is a topic of at least 20 PhDs, as you would agree, because aviation law is a very, very vast subject. Now, I would like to discuss some of the aspects about classicism in aviation law, now that you have the background. Now, I'm going to discuss really 3 concepts that were discussed right from 1910, which number 1 is that the state has full sovereignty over its airspace. Now, what a common man or common woman or anyone would not understand these days is that you can't just fly across any other third nation. A perfect case in point currently is the whole Russian-Ukraine war, where for reasons either political or for safety aspects, people may choose to apply to overfly Russia or not. Now, I say apply because it's not a matter of right that anyone has the ability to fly over anyone else's country. The Chicago Convention says that it should not be withheld, but at the same time, at least for civilian aircraft, permission is required. So just to give you a short example, we are working on a transaction currently where an aircraft has to be ferried all the way from India to Europe. Now, a very interesting fact is they have to get, when they file a flight plan, they have to get permission from each one of those countries along the way from India to Europe before they can overfly that airspace. These are things which people don't understand. So every time you're taking an international flight where you're flying over an international territory, there will be some paper trail, some email, there'll be some, whether electronic or actually paper form of permission that is provided to you. The second aspect, which I've already slightly touched upon, is that there's no right of entitlement to fly over another territory. That is, it touches upon the same point. The third aspect was really regarding registration, the aviation industry did borrow that from the maritime industry, where each vessel or each aircraft has a particular nationality. It has a registration. Now, to give you an example, in aircraft finance, when we work in aircraft finance, when we repossess an aircraft, say there's a defaulting party, and we are the owner. Say I lease an aircraft to Nivedita. Nivedita cannot pay me back or cannot pay the installments, and I have to go and take my aircraft back. The first thing that I want to do is I want to deregister it from wherever Nivedita is based. So let's say if she's based in India and I'm in Germany, the first thing I want to do is I want to go to the Civil Aviation Authority and ask them to deregister that particular plane, without which, according to the Chicago Convention, Nivedita can no longer operate that aircraft because an aircraft has to be registered. Now, you'll ask me, why is registration so very important? The Chicago Convention also ties the responsibility of safety, certification, and licensing on that particular well, it assumes that wherever an aircraft is registered, that country will be responsible for the oversight of safety of that particular aircraft. So that's extremely, extremely important. That's an aspect which we have seen in the ongoing Russia-Ukraine conflict, where now this is very important for persons to understand that despite Russia having its own civil aviation authority, the 90% of the aircraft were registered on other aircraft registries, meaning either the Cayman Islands or in Ireland, which meant that safety oversight for those aircraft have been delegated to a third country because they were not satisfied, or they weren't happy, or financiers weren't happy with the aircraft being registered in X, Y, or Z. So those are the concepts of which I would really term as classicism, which have stayed there from 1910. Of course, I'm not touching the topic of state aircraft. State aircraft definitely need prior permission before overflying any other territories. So in my head, those really are the concepts that we have that come from 1910, where countries realize that, okay, we have a behemoth in hand which needs to be regulated, whether it's the person flying the particular aircraft, whether it's the person who is responsible for having it land. It's absolutely, from A to Z, everything was dealt with by these conventions. Now, I'll move on very slightly to the concept of modernism. Now, what has changed? I would say not a lot. Not a lot has changed because, number one, safety again is paramount. We still have the concept of sovereignty over airspace. I won't go into the aspect of space law where you have aircraft that are limited to a certain altitude, but you have space objects which may go above 100 kilometers. Then that's been a very interesting topic for people to discuss. If you're above 100 kilometers over another country, who are you still in that airspace or not? So that's the moot point. I'm not going to get into that. Going back to modernism in international aviation law, what has changed tremendously from the earlier years till now is the number one aspect is aircraft financing. Now, when you throw yourself back into the early 1900s, financing was not a problem. Assets were not so expensive, mainly funded by the government. If there were airlines that were operating, they either had a lot of backing from the government, or there was a lot of state money that was coming in. With the advent of modern aviation, we have a plethora of financing coming through the private sector. So we have primarily the Cape Town Convention that we have currently, which deals with recognizing rights in aircraft. Now, look, this is not we're talking about an asset that's not a car. We're talking not an asset that's a train. We're talking about an asset that takes off from India, which lands, flies over 16 different territories and lands in say, the United States. We have two totally different regimes that apply, two totally different aspects of law that may apply. God forbid you have to make an emergency landing somewhere in between. You could possibly have 16 other jurisdictions whose laws would apply. That doesn't happen in any other industry. So this is very unique to aviation. That's why the industry felt that there was a need for a standardized recognition of rights. So that, if I'm say Professor Sreejith is one nation, Nivedita, you're another nation, so that when I'm operating between both of your nations, we have a standardized set of laws, and that you will recognize my ownership over a particular aircraft. So that is a very modernism, a very modern concept that's come into play. Again, because of the extremely high value of assets. We're talking about a couple of $1,000s earlier to at least the tens or hundreds of millions of dollars for current aspects. So that's one very important part. The second one is regarding the environment. Now go back to 1900, and even when I was young in the late 1980s, there was little or no consideration for the environment, because they were just, it was just not thought of. Now that has changed completely. And, when in Europe, when you purchase a ticket, you're actually told how many, CO2 kilograms you're going to contribute. And so that is one aspect which has tremendously changed. And that is really going to be a future aspect which has been discussed and will be discussed, whether it's, the ETS scheme, it's, again, these are all topics for PhDs, and there's only so much I can do in the time given to us. But environment and aviation have been at loggerheads with each other. If you ask the environmentalists, there's again, it's unpardonable for only 200 people to be flying so much and causing so much CO2 emission. If you ask the aviation analysts or the aviation supporters, they say that if you had to do the same trip length in other modes of transportation, it could have possibly been larger. The third aspect, which has really changed with modern times, is the aspect of passenger rights. Earlier, and again, many, many years ago, there was really little or no passenger rights that were available. Now that concept has really changed, and I give full credit to the European Union for that. I recall when I started my master's in the Netherlands, we studied EU Regulation 261, where they literally, again, I can't recall the exact numbers, but if it was delayed beyond, I think it was 4 or 6 hours, you literally got a whole chunk of money, which at those years, I was still struggling to get from Chandigarh to Goa, and we'd have to fly through Delhi, and there were, airlines with 8 or 9 hours delay because there was fog in New Delhi, etc. And those concepts were completely unheard of. Now, that's one aspect which has made tremendous amount of changes, leaps and bounds, whether you're talking about the Montreal Convention of 99, which substantially changed the ecosphere of liability and how much money you would get in case of bodily injury, baggage, or death, unfortunately. So that aspect has really changed. I think the whole outlook has changed to go from really being supportive of the operator to being supportive of the consumer. That has changed. Security is the fourth aspect I'd like to talk about. Again, stems from September the 11th, where before that, if you were a young child, you would be called into the cockpit of an aircraft, given a Toblerone or a fake hat, and you'd be allowed to sit in the jump seat for landing. It doesn't happen anymore, unfortunately. It's just the change of the world we live in right now. There's a lack of possible trust. There's a lack of ability to screen people. And as a result, and fairly so, security has been a major aspect. Now, security meaning whether it's standards in airports, whether it's regarding hijackings, whether it's going to be responses in hijackings, are also aspects that are dealt with by a number of conventions, by a number of national legislation also. Now, I promised to be very short. I'm at the 25-minute mark, but I do believe that a short introduction and a long question and answer session is always key. So I'm going to conclude with saying that aviation is fairly similar to where space is currently. Now, going back, say we're 1905, we are in the same position as far as space travel and space exploration is concerned as humans were back in 1905. So it's really time for us to take the space aspect also very seriously, because I think it's very basic human tendency to think that, oh my God, that's really beyond our means, or that's something, oh, that's Elon Musk's territory. That's, what he is going to do. But we must keep in mind that the Wright brothers were, the Elon Musk of 1905. These industries, the human race progresses because of people like visionaries, explorers, and people who follow their dreams. And I have full faith in our human capabilities. We are absolutely remarkable. So let's not discard that. That is going to be something of the future. Laws can never keep up with the pace of our development, as I started with, but they're fairly good. And I think India as a country, having dealt with our Ministry of Civil Aviation, we are changing. We are changing from that aspect of not wanting to listen to the industry. That is changing, and I see that change in the ministry every day, for which I'm extremely grateful, because that's the only way we can survive. And apart from that, I would like to throw the floor open after Professor is done with his presentation, just with a thank you and good luck.
Thank you for your address, Mr. Serene. I now invite Professor Dr. Sreejith to share his perspective on the topic.
Thank you. Thank you, Nivedita. Well, first of all, I'm in a little bit of confusion as to, am I really a guest in my own home? The society, of course, it's part and parcel of me, or rather, I'm part and parcel of the society, and I'm being invited to give a talk in the society. So whatsoever, let me play the role of the Executive Dean of the Law School. I take this opportunity to welcome Mr. Serene. It was absolutely a pleasure listening the aviation story from you, especially from a practitioner's perspective. I was thoroughly enjoying this. I was being a keen listener for the last 30 minutes. It was absolutely wonderful. So let me take this opportunity to thank you and also to welcome you to the Jindal Global Law School, to the Center for United Nations Studies, and also to the Jindal Society of International Law. I thank Ankit and Nivedita for inviting me to my own home and being a guest here. I enjoy this paradox, because I'm also going to talk about a little bit of paradox in international aviation law. My discourse is going to be a little bit academic. I'll try to make a critical intervention into the concept of classicism and modernism in international aviation law. I heard the term classicism for the first time in an article written by Judge Mohammad Bedjoy with the title Classicism and Revolutionism in International Law of Outer Space. Well, he was mainly talking about the innovative imagination, common heritage of mankind. I borrowed that term and used it for the first time in one of my pieces published in the wake of the Qatar diplomatic crisis and the air embargo in Air and Space Law, published by Kluwer, and of course, edited by Leiden University. So here, first of all, let me explain from an academic perspective, what do we really mean by a classicism and modernism? They're not definitely going to be substantially different from what Mr. Serene has presented. Now, classicism, from an academic perspective of international aviation law, is the sovereignty-centered discourse. Generally, we see this when international aviation law comes with the classical nomenclature, international air law. There is a heavy centeredness on sovereignty, and we see that Article 1 of the Chicago Convention celebrates the state sovereignty doctrine. Every state will have absolute and complete sovereignty over their airspace. So there is a paradox even here, that a pan-global activity like civil aviation is being governed by celebrating a restrictive doctrine like state sovereignty. But again, I said that international aviation law is a branch which has quite much of the paradoxes, unexploded paradoxes. So classicism in an academic discourse, when it is pitted against modernism, simply means the sovereignty-centered doctrine. And what is modernism? Well, modernism prioritizes safety. It would like to argue for some level of normativity to the safety, which at the moment takes the backstage in the in the all-encompassing aura of the state sovereignty doctrine. We all know that it's not just an aviation-specific doctrine. State sovereignty doctrine is at the very core of public international law imagination. So modernism prioritizes safety as the paramount doctrine of public international law. So here I'm trying to advance a case for an epistemological category called international aviation law, whereby I would try to reimagine this epistemology at 4 levels: the doctrine of sovereignty, sources, subjects, and meanings. The idea is that the classical discourse, which is sovereignty centered, which international air law popularizes, will have to be transcended and transcend to a new epistemological category, international aviation law, with new meaning and new substance, whereby safety would be the paramount doctrine. So my discourse would mainly focus on these 4 elements: sovereignty, as it is in the state sovereignty doctrine, sources of international aviation law, subjects, and then meanings. So let me start with sovereignty. Well, this is the core doctrine in international law. Sovereignty has been haunting the imagination of international lawyers, or rather, sovereignty has been looming large in the imaginations of international lawyers ever since the Peace of Westphalia. It has a historical character. It has a classical character. It is an imagination ingrained in all international legal discourses, in all international legal imaginations. We understand that this doctrine has 2 dimensions. One is the core dimension, whereby sovereignty is considered to be synonymous with the existence of the state, what we call sovereignty as the very life energy of a state. Wherever there is a state, there will be a sovereignty behind that. Or wherever you see a sovereign in action, there is a sovereignty to that sovereign. And second one is the other dimension. There's a beautiful terminology used by John Jackson to refer to this other dimensions of sovereignty, the slope over penumbra, which includes sovereign territory, sovereign jurisdiction, permanent sovereignty over natural resources, state consent, and such dimensions. So basically in international law, the moment you enter the discourse of international air law, you find both the core dimension and the other dimension looming large before your imagination. And then you start to read the Chicago Convention. Article 1 of the Chicago Convention literally celebrates the state sovereignty doctrine by declaring that every state shall have absolute and complete sovereignty over their airspace. And then the paradox starts. As Mr. Sreejith mentioned, you start to read a series of exceptions to the state sovereignty doctrine, which allows a pan-global activity like civil aviation to be carried out. So, but you are stuck at the moment by a restrictive doctrine of state sovereignty, and then you read international aviation law through a series of exceptions, only to climax in Article 89, which uses another interesting language, that during war and emergency, the Chicago Convention, under the Chicago Convention, the states will have absolute freedom of action. Well, it doesn't say that Chicago Convention will be suspended or will become inoperable. It institutionalized some type of lawlessness. The course of action will be decided by the states. Article 89 has the undertones of politics. It speaks a political language because war and other emergency. During war and other emergency, the states have the freedom of action. That means that states are literally left to make their political choices over every legal consideration the Chicago Convention has put in place. Well, this has been extensively explored by this particular term. The freedom of action has been extensively explored by Nani Palkhiwala in India versus Pakistan dispute before ICJ in 1971. Anyway, the paradox is that you have a restrictive doctrine of state sovereignty and then a series of exceptions, only again to find that, well, Chicago Convention literally lets the state to have their freedom of action, what we can casually say lawlessness, or the states to make the political choices when there is war and emergency condition. Now, it is this celebration of the state sovereignty doctrine which we are problematizing, because at times the overarching imagination of the state sovereignty at times eclipses the safety concerns. So anyway, the state sovereignty doctrine, there is no disregard to it, because we know that Mr. Sreejith pointed out to some of that. There are historical reasons why Chicago Convention had to celebrate state sovereignty doctrine, because Article 1 of the Chicago Convention, and the convention itself was seen as finally a refuge from the bloodshed and the war and the devastation which humanity has witnessed. At that point, what they wanted was to safeguard the skies from alien attacks. Hence, you find the language of a celebration, a jubilation in Article 1 of the Chicago Convention. You will find the same kind of jubilation in Article 5 of the Outer Space Treaty, whereby astronauts are declared as envoys of mankind. So here, law at times can be the site of celebrating the human triumph. That's why legal philosophers have said that. You look at the law, you look at your history, you look at the self-evolution of humanity. So Article 1 of the Chicago Convention, if you read it with a historical eye, you will understand that, well, Article 1 is an achievement. It's a triumph for the humanity that it ultimately saved the skies from the alien attacks. And if you look at the Paris Convention 1919, Article 1 of which ultimately inspired the Chicago Convention, well, Paris Convention also reflects the Article 1 of the Paris Convention also reflects the apprehensions and anxieties of the First World War. The same is reflected in Article 1 of the Chicago Convention. Now, so that's why historically understanding the doctrine will give it a certain order. But then the question is that whether that historical baggage has still to be carried to the contemporary times when safety of the passengers, safety of the flight is paramount. So the same doctrine and whatever sentiments are historically associated with it continues to govern the civil aviation even today. So states often abuse this absolute sovereign rights of over their skies in order to satisfy their political caprices. And we have seen this, especially in the form of suspending the right of overflight. Chicago Convention continued like this for many years. And the final breakthrough came in 1984, when Article 3 bis was added to the Chicago Convention by way of the first main amendment to the mainland of the Chicago Convention. Of course, annexures went on mounting as time eclipsed. We have 19 annexures today. Even the last annexure was added in 2013. However, the major amendment to the Chicago Convention happened in 1984 when they added Article 3 bis, which said to, which urged the states to refrain from resorting to the use of weapons against civil aircraft in flight. Now, this is the first note of safety in the mainland of the Chicago Convention. Now, this restricted absolute exercise of the sovereign powers of the state, because before resorting to weapon against a civil aircraft, states are required to exercise moderation, states are required to rather refrain from that. So this restricted for the first time the absolute sovereign rights of the states, the sovereign rights of the states, which were celebrated in Article 1 of the Chicago Convention. But when there are interceptions, states can again resort to any appropriate measures consistent with the rules of international law. Well, when it's any measure consistent with the rules of international law, you have to read it in the light of the International Law Commission's Articles on State Responsibility, which even permits a state to go for collective countermeasures. Anyway, Article 3 bis is interesting because for the first time, it brought in a safety dimension to the Chicago Convention, which otherwise is deeply rooted in the state sovereignty doctrine. But if you read the convention in full, again, I'm saying what has been given has been taken away as well. So from a critical perspective, we could say that Article 3.1, even though can be considered to be the first note of safety in international law, it rather institutionalizes that paradox we talked about. Because Article 1 celebrates sovereignty, then we have a series of exceptions. Nowhere you could find this institutionalized. Now, by juxtaposing sovereignty with safety in 3 bis of the Chicago Convention, international air law or international aviation law actually institutionalized and formalized the above said paradox. Now, where do we go from here? If we reimagine international air law under a newer epistemology, international aviation law, where do we go from here? I would say that we need to now have insights to think beyond sovereignty. Now, here I would like to draw on the insightful observations of an American professor, John Jackson, who wrote a celebrated article in American Journal of International Law called Sovereignty Modern. So he said that with the fall of modernity, well, the sovereignty doctrine has become somewhat irrelevant as the doctrine was classically understood. Today, in a globalizing world, in a rapidly globalizing world, we understand sovereignty in a different way. It's no more the state's power to monopolize its people, its territory, and its decision-making powers. Rather, sovereignty today is horizontal allocation of powers among the relevant global actors. Now, I'm not getting into the details of that article. This is a celebrated piece in 2002, published in the American Journal of International Law by Professor John Jackson. But in the context of international aviation law, especially with the focus on the safety, horizontal allocation of power could moderate the unbridled exercise of the classical doctrine of the sovereignty. That means at least there will be a rational exercise of state sovereignty by the states when sovereignty is understood as horizontal allocation of power among the appropriate actors, among the local, the global, and the national actors, rather than states centering all the powers and being the decision maker. Well, of course, even in horizontal allocation of power, state doesn't disappear. The state simply allocates sovereign powers among the relevant actors. Now, this rational approach entails a more policy-oriented approach. The moment we say that the states need to rationally approach the sovereignty doctrine through analytics like horizontal allocation of power, this demands more policy-oriented approach, giving space for economistic considerations as against the pure normative practice. That means that before celebrating state sovereignty doctrine, we should also look into elements like safety, optimality of the market, and most importantly, public interest. This is the first case I submit as we try to reimagine international aviation law. Second one is, my second point is sources. We all understand that the classical discourse on international air law traces international air law to Article 38.1 of the Statute of International Court of Justice, which we consider as the source doctrine of international law. Well, if you look at the critical side of Article 38.1, especially the postmodern writings on international law, scholars have called Article 38.1 more as methodological pretension of international lawyers by way of a self-assurance, or international law scholars who, by way of a self-assurance, stated that, look, we too have a source from where international law emanates. But the problem with Article 38.1 in its application to international air law is that international air law doesn't often emanate from, all the time, from treaty or customary international law or general principles of law recognized by civilized states or writings of highly qualified publicists. Indeed, we know there are treaties: Chicago Convention, Warsaw Convention, Montreal Convention, Tokyo Convention. Conventions definitely rule. But customary law we generally do not find in international aviation law, even though we find a lot of cockpit etiquettes and airline etiquettes. We generally don't find customary law as it is understood understood through state practice and opinio juris in international law. But international aviation law mainly comes in the form of contracts between airline companies, standards and recommended practices issued by national civil aviation agencies, many times in the form of exchange of letters between governments. The problem is that Article 38.1 cannot legitimize many of these discourses. So you can often find that in all the international air law discourses, there is a failure on the part of the scholars to legitimize some of the real sources of international law, because Article 38.1 doesn't simply have the imagination or the bandwidth or the space to accommodate the innovative and outstanding sources from which international aviation law emanate. So the classical discourse of international air law struggles to earn a legitimacy to the sources of international air law. Now, Article 38.1, we also know that it has an emphasis ultimately on state sovereignty, because the language of treaties, or the language of customary law, or the general principles of law recognized by civilized states, you can sense the state centrism as you go deeper into opinio juris and state practice, or as you go deeper into the general principles of civilized states, you can again sense sovereignty emanating all the time. So first of all, the deep rootedness in sovereignty of Article 38.1 is a misfit for international aviation law. Second, as I said, 38.1 is drafted with different purpose. It cannot legitimize many of the sources. This is a failure on the part of the scholarly discourse. You could find the discourses literally struggling to get a legitimacy for international air law under Article 38.1. So when we try to transcend international air law to move into that branch of law called international aviation law, probably we could try to derive a new source doctrine for international aviation law, which is more safety centered. And this source doctrine shall have the scope to contain structures of regulation and control which govern civil aviation, structures of regulation and control which govern civil aviation, rather than constraining behavior through the grids of normativity like Article 38.1. So what shall be the constituents of those source doctrines? Definitely, we cannot talk about international aviation law divorcing us from conventions, because starting from the Paris Convention 1919 through Chicago Convention and the entire Warsaw system, the Tokyo Convention, Hague Convention, Montreal Convention, Beijing Convention, but we absolutely cannot talk about international aviation law disjuncting us from conventions. So conventions will have to stay. We'll retain the essential element of Article 38.1 and the most prominent and structured source of international law, the conventions. But then, instead of moving to customary international law, SARBs shall become a sources of international law, the standards and recommended practices. Now, today, we find the SARBs, the standards and recommended practices, in the normative periphery of international law. Even look at Chicago Convention, Article 1 to Article 96 is considered to be the hard law, which has a thick normativity. The moment you move to the annexures, well, they are deemed to be SARBs, standards and recommended practices, the soft law domain of the Chicago Convention. Hence, I use this word with a little bit of irony here, that the mainland of Chicago Convention and then the peripheries. But you find the SARBs. Actually, it's the SARBs which ultimately regulate the civil aviation. It's the SARBs which ultimately fetches safety in civil aviation. The SARBs we can find only in the normative periphery. So if you start to read sorts in the light of the annexures of the Chicago Convention in the light of Article 38.1, well, we'll struggle for the legitimacy and normativity because they are not enforceable. So conventions followed by standards and recommended practices. And the third one, I would say standard operating procedures, which actually are the rules of the game. Ultimately, we have a safer aviation because standard operating procedures are followed. Well, standard operating procedures are literally present in every stage of civil aviation, starting from the design of the aerodromes onwards to the baggage check, onwards to the check-in, onwards to the takeoff, the climb, the cruise, the descent, the approach, the landing, and even the taxiing. So you find literally observance of standard operating procedures at all stages of the civil aviation. You cannot have a discussion on international aviation law divorcing one from SOPs, because SOPs are not within the larger framework of Article 38.1. That doesn't render SOPs irrelevant. So what we need is actually, we've had to get into the, if safety is the ultimate goal of international aviation law, or if law serves to achieve safety, then of course it's time that we go beyond, or we look beyond Article 38.1 to reimagine the sources of international law by giving a newer legitimacy to conventions, standards and recommended practices, and standard operating procedure. Now, there may be a question where the domestic legislations will come. Well, most of the domestic legislations on civil aviation are either are nothing but the standards and recommended practices given a larger enforceability. So they could very comfortably fit without much tension within the SOPs category. So conventions, standards and recommended practices, and standard operating procedure, which are the rules of the game, shall be the constituents of the reimagined source of international law, because they take us to the very heart of international aviation law. Now, international air law have this kind of a modernism, but that modernism is not much celebrated as the state sovereignty doctrine. For example, we all know that bilateralism, which is more political, is often considered to be an innovation in international air law. Bilateralism doesn't come with the same kind of normative power as multilateralism in international aviation law. States feel free to break the bilateral agreements because civil aviation often are driven by political choices. But this bilateralism has always been considered to be a modernism in international air law. Well, even though they never literally came into the aviation law category. Then open skies policy is nothing which will fall into the category of the positivistic hot law, but they have always been deemed to be the policies. And most importantly, if you look at the Montreal Convention 1966, often we talk about that as an agreement, but we all know that the Montreal Agreement 1966 is just a compromise formula. But you remove Montreal Convention from the narrative of the Warsaw system, the evolution from Warsaw system through the Hague Protocol, through the Guadalajara Convention, through the Guatemala Protocol. You cannot, until the Montreal Convention 1999, you cannot discuss that by removing this compromise deal called the Montreal Agreement 1966. What does this mean? This means that even a political compromise was part of international air law, but we do not celebrate all that. We should have celebrated this evolutionary paradigm, because international air law had this evolutionary paradigm. It displayed an evolutionary approach to international law, which law never celebrated, or legal discourses never celebrated. Rather, we went on to celebrate the state sovereignty doctrine and pushed bilateralism, open skies policy, and these political compromises to the periphery of our legal imagination. The third point I would like to discuss in the journey to the modernism is actually subjects, or in this polarity of classicism and modernism is actually the subjects of international law. So when we talk about the subjects, we generally speak about bearers of rights and duties. Now, if subjects are classically understood, only states will qualify as the subjects of international aviation law, because in order to be a subject, you need to have this deontology to you. You shall have certain rights, certain duties to you. And by having certain rights and duties to you, you get something called a publicness. It's this publicness which makes you a subject. So whenever we talk about subjecthood in jurisprudence or subjecthood in international legal discourse, we ultimately talk about those who are bearers of rights and duties. That is, in international aviation law, the problem here is that there is only one subject, state. To some extent, you find passengers as well. But there are numerous functionaries in international aviation law who are silenced in the law, who generally live in the peripheries, in the annexures, and in the many SOPs and SOPs who ultimately make our flying safer. Functionaries are not celebrated in law because they're not subjects, because they don't hold any rights or duties. There is no specific legal status to the functionaries in international aviation law. So in modernism, I mean, at least we live in a postmodern world, and we believe that international aviation law has also advanced towards a certain modernism. We should let the subjects break their silence, because in the periphery they were speaking, but the voices from the periphery were never heard in the to the scholarly eyes, to the scholarly, never fell into the scholarly ears. So let the modernism of international aviation law let the subjects speak, the silenced ones speak. Their representation in the normative land, let them represent themselves in the normative landscape, and let their voices add to the safety dimension. Now, who are these functionaries? Well, you just need to go through the annexures of the Chicago Convention: pilot in command, co-pilot, cabin crew, traffic controllers, air crash investigators, and many employee union federations and passengers. They do not get a representation in international air law, again, due to the classical discourse of subjecthood. Now, I would like to illustrate this representation in a little bit more by submitting before you the case of pilots. If you read Chicago Convention, especially the main body of the Chicago Convention from Article 1 to Article 96, you will find only one reference to the pilots. That's in Article 32 and Article 33. Here, if you read the language of Article 32, you will only find the licensing power of the state over the pilots. That means the power of the state to license the pilots. The language is to the state. State is the bearer of the rights and duty here. Pilot just becomes a functionary, again, living in the outskirts or living in the peripheries of the Chicago Convention. Now, the moment you read Annexure 1 of the Chicago Convention, which is a soft law here, which is on pilot licensing, it has an outstanding and extraordinary focus on the skills and competencies of the pilot. The safety dimension is addressed there. Now, if you go by Article 38(1), then you know that these voices literally do not get represented. Only the voice of the state's right to license the pilot gets a representation. I would like to illustrate this further. There is an interesting terminology in para 2.4 of Annexure 2, which speaks about the rules of the air. It says that the pilot in command shall have absolute authority over the dispositions of aircraft. Now, disposition is generally not a terminology or not a quality which we attribute to inanimate objects like the plane. So somewhere the law here recognizes that there is a psychological connection between pilot and the plane. I always call it the romance between pilot and the plane. Now, if you look at the way the pilot flies a plane, especially their emotional response to altitude and the speed, pilots are what you call embodied aerial subjects. Their emotional response is different from everyone else. It is their emotional response, their reaction to the height, reaction to the speed, being the embodied aerial subject, which ultimately fetches us, or which ultimately gives us which ultimately renders our flight safer. Now, this safety dimension, again, in order to find that, you have to go to the annexures of the Chicago Convention, which will not find any legitimacy under Article 38(1), because they will be pushed into the peripheries as soft law. There are also further topics like pilot fatigue, which ultimately contributes to the safety. So instead of giving pilot fatigue an honorable place in the normative space of the Chicago Convention, they are again pushed to the subnormative spaces of the annexures. That means our real imagination of subjecthood should change. We cannot continue with that old notions of the subjects. That subject is the one with rights and duties, but it's time to let the functionaries come to the sender and speak, because it is their speech which will give us a perfect perspective into the safety dimension. So let the pilots, the cabin crew, the traffic controllers, the pilots federation, and the passengers speak in aviation law. So the newer imagination called international aviation law should break that old discourse whereby these people are silenced. We need a new discourse whereby their voices shall be heard. And my fourth point, I'll finish another 5 minutes. My fourth point would be on the meanings. Now, here too, that international air law, as every other branch of the law, is a slave to semantics. That means meanings always unfold based on the context in which they operate. For example, the term standards and recommended practices. I need not tell you how important are SARBs to ensure safety in international aviation. However, in international air law, SARBs designated as SARBs by ICAO. So the meaning is so much, left to an institution and left to a certain context. What about the recommendations in an air traffic investigator's report submitted under Article 13 of the Chicago Convention? Well, they are crucial because many planes cannot even take off after an accident unless the aircraft investigation report of that particular accident comes out. Why not an instant normative effect for the air crash investigators' recommendations because they ultimately contribute to the safety here. Why you need to wait for the report to be submitted to ICAO and go through the institutional mill finally for that to become a SARBS? So what about the guidelines issued by the Federation of Airline Pilots? What about the guidelines issued by the Traffic Controllers Association? What about the guidelines issued by national civil aviation authorities? You need to wait for them to get a normative, to get the status of the SARBs only by going through the mill. So SARBs are what are designated as SARBs by ICAO here. Now here we can see that there is a deep embeddedness of meanings in certain contexts. It's high time, as in every other branch of the law, that meanings in international aviation law to get decontextualized. Today, such a movement of decontextualization is literally happening in every other branch of law. It's time that international aviation law to espouse this trend or this sensibility which is prevailing in other branches of the law. So meanings ultimately shall be driven by the efficiency of outcomes, not based on a recognition by institutions, or what I would call the regimes of normativity, for them actually for a life to unfold from those meanings. So under these four categories, well, these are basic constituents. Of course, there are many areas like discourse and semantics and semiotics, which need again a reimagination. However, these are the broad four pillars: sovereignty, sources, subjects, and meanings, reimagining which would slowly give rise to an epistemology. I'm not here claiming that international aviation law and international air law are two different disciplinary categories. However, in order to transcend the classicism of state sovereignty as an international air law discourse and to move to the modernism so that safety becomes the paramount norm and skies become safer and safer, public interest is upheld, we actually need to move into a newer epistemology with newer meanings. It is this newer epistemology which will ultimately become the guiding force for all practitioners, airlines, strategists, and including international organizations. So on this note, I complete on this note. Happy to take any questions. Thank you very much.
Thank you so much, Professor Dr. Sreejith, for your address. I would like to now open the floor for questions. I believe Mr. Sareen has a question he would like to pose to you.
Yeah, Professor, thank you very much. First of all, I agree with you that safety has to be paramount, and I've never looked at it from that perspective, and I appreciate that perspective that you've given me. Just another comment that I have after listening to you was, again, not related to the topic, but related to the study of law in general, that I have enjoyed your discourse so thoroughly, and I've understood your discourse so thoroughly after the experience that I have gained in the profession from a practitioner's point of view, which I could not have fathomed back in 2008. So it may be a good point for all our listeners to note that the tools that we get with a master's or a PhD are very important. So please use them wisely. And once you're very certain as to what you enjoy and where your passion lies. Now, on that same note, I would like to ask you, Professor, are you an aviation fanatic? Are you an aviation geek? How have you done so much research in this field? It's absolutely fantastic. And I really appreciated your discourse. But what is the background and why so much research in this field?
Well, thank you, Mr. Sareen, for that very interesting question. In fact, I entered aviation through legal philosophy. My background is legal philosophy. It is analytical jurisprudence. People generally don't approach these disciplines. They either approach from a very doctrinal perspective or from a very strategic perspective. So when I entered this field, of course, my first contact with international aviation law is through the writings of Mr. Urubantisa Aberatne, whose writings I even continue to enjoy because, to my knowledge, he's a rare scholar who makes critical interventions into international aviation law, who tries to speak on behalf of these silenced subjects in international aviation law, not only aviation law, even international space law. So I reached international aviation law through international law of outer space, having read and enjoyed the overall of many of the scholars there. So I mean, of course, I don't know much about the technical sides, but I always feel that when we had you in this session, when we heard you, we heard an altogether different narrative. which generally we don't reproduce in the classrooms. So an international aviation law textbook cannot give us the perspective of a practitioner. Your own professional sensibilities as an aviation practitioner, the challenges you face, routine challenges you faced in your profession, such sensibilities do not get recorded in the discourse. But it's an academic's responsibility. I believe that they are all recorded, because we academics, we are not scientists, we are not innovators. What we do is that we capture all the occurrences. Yes. We give it the character of a discourse and a theory, so that there is a shelf life for it, so that progeny understands this, because society has a fleeting memory. Everything you do and speak this moment will be forgotten tomorrow. Yes. Academic intervention would try to preserve that. I felt that there is this void. I mean, of course, I cannot speak on the nuances of flying, but I still understood that there are many elements or the phenomenology of the pilots are completely ignored in international aviation law. And once I even read a brilliant piece by Kane and Payne in the journal Air and Space Law, in which he mentioned that the first officer is another silenced subject. Yes. He is just or she or they are just shadows of a legal shadow of the captain, a legal shadow of the pilot in command. Now, this is a tragic existence, because we ultimately know that conversations in the cockpit query the command, which ultimately can lead to better safety, democratic decision-making in the cockpit. At least query the command, rule out the query posed by the first officer with logic before you ultimately ignore that, or ultimately decide not to implement that. So many times I felt that, again, first officer, another silenced subject. So my jurisprudential background actually helped me to come and speak for those subjects. I feel, again, cabin crew. People don't understand that cabin crew are safety officers primarily. Yes. They do serve food and drinks. They are safety officers primarily. It is ultimately when something happens to the plane, they take charge of the safety even before the cockpit could do something for us. Because the emotional response of a cabin crew towards an emergency, well, again, it is something to be learned. And another important element I felt always, which is ignored in aviation law, is the cockpit resource management or the crew resource management, which again contributes immensely to the safety. So I am trying actually to be the representative voice for the unrepresented. That's exactly my approach to aviation law. I do not claim to have the kind of expertise as you have in terms of leasing and licensing and M&A and such routine things in the aviation.
No, but just a quick comment about that. I think you touch upon a very important topic, which also includes a cultural background, where what you touch upon with first officers being silenced, which is much more prevalent in countries like India, countries like Turkey, where you have captains who have been in the Air Force who are not prone to taking into consideration what a alleged subordinate is saying. That is a very, very valid point. And
I've noticed a particular expression used in the Inquiry Commission's report, the Inquiry Commission's report on the Mangalore crash. Yes. Whereby the first officer's queries were not answered by the captain, which ultimately led to the plane overshooting the runway. So they used an expression, the transcultural gradient in the cockpit. I believe that this should come to the aviation law classes, the concept of transcultural gradient in the cockpits. And it should be explored in great detail by the international aviation law as a discourse, so that this ultimately gets a normative character and should be internalized by every cockpit crew. So I'm just advocating for those silent voices and silent perspectives, which I believe would immensely contribute to safety. Because having studied aviation law, I thank silently the pilot after every flight, because there could be 100 things could go wrong. There is only one way of right flying, and every safe flight is that those 100 things or that they got everything right. So yes. I silently thank the functionaries who are silenced in the law. So I'm just trying to be the representative voice for the underrepresented. That's why this effort at reimagination.
Wonderful, wonderful, wonderful. Thank you.
Thank you. So I think this discussion has perfectly brought out the perspectives through both an academic perspective as well as practice in international aviation law. And my question sort of ties these two perspectives together. And I open both the speakers to answer this question. So my question pertains to the conflict that arises between the two norms in international aviation law. So that is the safety norm and the principle of territorial sovereignty. Especially when we look at the different situations that may arise, that may present the conflict between or the clash between these two norms, such as if we look at Article 25 of the International State Responsibilities, which is the self-defense one, or Article 85 of the ICAO Convention itself, and then we go back to, and then we look at how, and then we go back to Article 6 of the ICAO Convention that expressly states that you require permission or authorization from the state to enter into a state's airspace. So what happens when such situation arises where there is a clear conflict between the two norms, and this conflict especially is relevant with regards to imposition of liability, because this liability would require the balancing of the two norms and would also imply that there somehow emerges a super norm when the two clash. Thank you.
Okay, let me try to provide an academic perspective to this. I think, we should not disregard the Chicago Convention just because, or we shouldn't consider Chicago Convention as anything inferior just because there is a conflict there. I believe that this is an outstanding experiment in lawmaking, because today we have the concept of Framework Convention, a United Nations Framework Convention on Climate Change. We talk about the WTO agreement, the Marrakesh Agreement establishing the World Trade Organization. But in 1944, they drafted a Framework Convention whereby they tried to accommodate numerous considerations within one. Indeed, they could not give normative value actually to the safety dimension, because in 1944, I said that due to all the historical reasons, Chicago Convention had to emphasize and reiterate and re-emphasize and reiterate the sovereignty dimension. But of course, that was an experiment done in a historical time, in a historical space. But as time evolved, Chicago Convention still tried. But the problem is not here with the Chicago Convention. Tell us how much public international law is willing to compromise on the state sovereignty doctrine. Professor John Jackson's article on horizontal allocation of power, it's considered to be a rationalism. It's a skeptical approach to classical public international law. I mean, of course, it is popular among the rationalist circle. So Professor Jackson was even critiqued for being a political realist, advancing a legal claim or advancing a newer doctrine of sovereignty. So the problem is not just with international aviation law. Public international law still has a deep rootedness in the state sovereignty doctrine. Now, the state can abuse this doctrine. You know that. I mean, any state can suspend its airspace anytime in the name of the state sovereignty doctrine, even to sabotage a market competition. Now, if other state comes and argues that, well, this is unilateral trade sanctions, you cannot do that, this is a protectionist measure. Well, even no trade law canon prevents a state from invoking a protectionist measure in the name of state sovereignty. So the problem is that the sovereignty doctrine is so deeply ingrained in the imagination of public international law. The problem is not with Chicago Convention. So I love Chicago Convention with all these inconsistencies, the paradoxes, and the conflict, because I've never seen such a fantastic experiment in lawmaking. So Nivedita, I would say that even when there is a conflict happens, I view it with a fine sense of irony, a fine sense of learning, because, you know, Chicago Convention is a site of experiments, a site of different normativities clashing. There are numerous. I mean, these are just a few points, but if you look, the deeper you go into the convention, you know, you will find that probably there has never been such a fantastic imagination in lawmaking. So in this slide, you have to look at your question, because I cannot exactly answer how you will resolve this conflict, but that conflict is not meant to be resolved, because that conflict is not meant to be resolved. As of now, Chicago Convention is a site of pluralism, whereby the two doctrines, sovereignty and safety, exist in a tension. And in the tension, what we could probably do is that you could take things a little bit, you know, in a radical perspective, that you read the same Chicago Convention, which you have been reading classically, with a rationalist vein. You could do that again with this kind of spiritual vein I talked about, the relationship between pilot and the plane. So let that pluralism prevail in Chicago Convention. For the time being, let that pluralism be the governing perspective to look at the conflicts within the convention.
And to add a possible practitioner's point of view, if there's a conflict between sovereignty and safety, let me give you an example. Say we have a JFK to New Delhi flight that's operating. Let's say the flight has reached just before Pakistan. We've reached, just say, the Afghanistan airspace. And for whatever reason, there's some conflict between India or Pakistan, or there's some, you know, some issue there. And suddenly they say, okay, Air India 174, whatever the flight number is, you're not allowed in Pakistani airspace anymore. And they're in a critical situation where they either have to divert to somewhere like Dubai or Sharjah, or they continue beyond, let's say, an hour beyond their maximum limit which they can legally operate. Now, what would happen? It would rest on the decision making by the captain, where he would decide to see whether they are exhausted, whether turning around over the Arabian Sea will make sense or not, whether they want to do that extra hour and a half. So practically, it makes the real decision does lie with the actual person who's on the ground. Once they land, yes, they'll have to file a report, etc. What will happen with it? No one knows. I mean, that's the practical sense of it. But every day there is a conflict between the safety and the sovereignty. And unfortunately, as Professor rightly points out, it's the crew who face the brunt of that. So it's anyone's guess how to resolve that. Whether it's going to be resolved or not, I don't think it's going to be resolved. But international civil aviation has always taken the brunt of all the political aspects of it basically gets the short straw at all times.
That's a very, very interesting perspective. I forgot to add something here. There are circumstances when sovereignty can become the safety norm. Look at Article 89. Article 89 says that during war and emergency conditions, states have the freedom of action. That means that you exercise your sovereignty, because in war and emergency condition, safety norms cannot be upheld. You cannot follow the safety. So state sovereignty actually becomes the means at that time to ensure the safety. So even though I critiqued it for being a paradox of safety and sovereignty, that beautiful terminology, the freedom of action, the Chicago Convention has allowed political considerations to enter.
Yes.
That actually becomes the means to achieve the safety. Same is the case with Tokyo Convention. The captain is invested with magisterial powers when the plane is when there is a crime on board the plane. When the plane is hijacked, so much of powers are invested upon the captain, as Mr. Sareen rightly pointed out. So that's what I said. The convention has, of course, no convention is perfect, but Chicago Convention is an outstanding experiment. A pluralist perspective would be which could develop empathy towards the convention and make the convention functional. Functional and serviceable under the conditions.
Indeed. I want to thank both the speakers, Dr. Sreejith and Mr. Sreejith, for answering my questions so patiently. I want to invite Mr. Malhotra to say the final words and conclude the lecture. Thank you. I think he's facing some technical difficulties. If you may just wait.
Maybe Nivedita, you should express thanks to Mr. Sareen on behalf of the school.
Yes, indeed.
Sorry, I was just trying to log in. Let me just say that I'm torn right in the middle. One half of me wants to work in the chambers of Mr. Sareen. The other half wants to work as an RA with Professor Sreejith. I think there could have been no one else better to speak about this topic than these two experts which we had today. I would like to thank them from the bottom of my heart for doing this on a busy evening, on a day which requires so much thought and so much perspective, and also time scheduling. And since these are aviation experts, they really value time and understand the importance of it. I'm also thankful to Nivedita for taking out time and moderating this session and for approaching me, because this was her initiative, her drive. I was only the one in the backseat taking care of the admin. I also thank once again our participants for taking out time for this. And now invite our speakers to just share a final word, and then we can close. But before I do that, I just want to say one final word as a note of acknowledgement to Mr. Sareen specifically. We hosted around 100 speakers, all from different parts of the world, but no one, absolutely no one has acknowledged Mr. Vikas till now, or the others who worked. Perhaps this stems from his frustration of the Indian courts and their inability to be able to take care of this. But as Professor Sreejith knows, and also Nivedita knows, the IT team has done an absolutely fantastic job, who worked with me tirelessly. They deserve a round of applause, and so does so does the entire administration and function of the university. And we are so grateful to Professor Sreejith for shepherding us, as Foucault would put it, and for taking care of us and the society and all our aspirations and the initiatives which we have. We are so grateful to the university for giving us this platform. And as a young student, once started out by reading articles on Google Scholar, and the tagline there ran, "Stand on the shoulders of giants." And today we truly feel that we stand on the shoulders of giants of an important field without which we would still be in the Stone Age. We're so thankful, and we're extremely indebted to both our speakers for doing this. Nivedita, final words from the speakers, you can invite them, and then we can close. Thank you, everyone.
With that, I would like to invite both speakers for final words. Thank you, Ankit, for your address.
Well, just 3 points. Number one, I'm highly envious about where you guys study. The whole atmosphere of education now has changed from when I was in law school. So extremely envious. Number two, I'm sorry, the RA spot, if it's going to come with Professor Sreejith, I'm taking that. That's not for you. And lastly, the ability and the importance of thanking everyone, I actually learned from Dr. Abdul Kalam when he came to inaugurate our university, where he had all the chief ministers of the states of Punjab and Haryana on the dais, but he started with the 2 compeers who were students of the Army Institute of Law. And that is something, humility is key in life. I think that's very, very important, because you don't work unless everyone around you is working properly. So with those words, thank you very much.
So I'll take this opportunity to thank Mr. Sareen on behalf of Jindal Global Law School, OP Jindal Global University, for being our guest. I absolutely love your art of storytelling. I mean, it was phenomenal, actually. I wanted actually to close my eyes and listen to that story, the aviation story you narrated from 1911. Especially that story had many things which you generally don't get to read in a book on aviation history, or the narration on aviation. Because you added your own personal experiences. So it was absolutely a lovely story I heard. Kudos to you for your storytelling abilities. So finally, on behalf of the school, I thank you here. We are truly honored to host you, and we look forward to host you on our campus sometime to give a public lecture on the aviation practice to our students. Thank you to everyone associated with it. Ankit, Nivedita, thank you very much. And also to my own IT team, a wonderful job, phenomenal. Thank you. And good night to everyone.
Good night. Thank you.
Thank you, everyone.